Hello everyone. We are still in Article 129, which states that search warrants maliciously obtained and abused in the service of those legally obtained. In addition to the liability attaching to the offender for the commission of any other offense, the penalty of arresto mayor in its maximum period to prison correctional in its minimum period and a fine not exceeding 200,000 pesos shall be imposed upon any public officer or employee who shall procure a search warrant without just cause or having legally procured the same, shall exceed his authority or use unnecessary severity in executing the same. The following are the requisites for issuing a search warrant. First, only upon probable cause. Second, one is specific offense to be determined personally by the judge after examination under oath or affirmation of the complainant and the witnesses he may produce. And lastly, particularly describing the place to be searched and the thing to be seized. Let us examine the case of Alvarez versus Court of First Instance et al. The facts are as follows. Petitioner Alvarez asked that the warrant issued ordering the search and seizure of certain accounting documents, as well as the order authorizing the agents of the Anti-Usury Board to retain the articles seized, be declared illegal for the alleged money lending activities, charging usurious rates of interest in violation of the law. The usury law in the Philippines provides that no person or corporation shall directly or indirectly take or receive in money or other property, real or personal, or chooses in action, a higher rate of interest or greater sum or value, including commissions, premiums, fines, and penalties for the loan or renewal thereof, or forbearance of money, goods, or credits. Petitioner contends that Agent Almeida has no personal knowledge of the facts, which was served as the basis for the issuance of the warrant, that he got it only from the reliable source. Thus, the search warrant issued is illegal. The articles had not been brought immediately to the judge who issued the search warrant. The issue of the case is whether or not there was a valid search warrant issued, seizure, and order. Let us examine the three elements if those elements are present in the case. The first element is only upon probable cause. The Supreme Court held the first element is not present because Section 98 of the General Orders, number 58, provides that the judge or justice must, before issuing the warrant, examine under oath the complainant and any witnesses he may produce and take their depositions in writing. It is the practice to attach the affidavit of at least the applicant or complainant to the application. It is admitted that the judge who issued the search warrant relied exclusively upon the affidavit made by Agent Almeida and did not require of any other witnesses. The affidavit of the agent was insufficient because his knowledge of the facts was not personal but merely hearsay. When the affidavit of the applicant of the complaint contains sufficient facts within his personal and direct knowledge, it is sufficient that the judge is satisfied that there existed a probable cause. But when the applicant's knowledge of the facts is mere hearsay, the affidavit of one or more witnesses having a personal knowledge of the fact is necessary. Therefore, as to the first element, there is no probable cause because the warrant was issued based only on the affidavit of the agent who had no personal knowledge of the facts. Let us examine the second element. One specific offense to be determined personally by the judge after examination under oath or affirmation of the complainant and the witnesses he may produce. Section paragraph 3 of Article 3 of the Constitution provides that no warrants shall be issued but upon probable cause, to be determined by the judge after examination under oath or affirmation of the complainant and the witnesses he may produce. In this case, it appears that the affidavit which served as the basis of the search warrant is defective by reasons of the manner in which the oath was made, and therefore it is hereby held that the search warrant in question and seizure of the documents are not valid. And finally, let us examine the third element of a valid search warrant if it is present in the case, which states that particularly describing the place to be searched and the thing to be seized. The Supreme Court held it is not present because Section 1, Paragraph 3 of Article 3 of the Constitution and the Section 97 of the General Orders Number 58 provides that the affidavit to be presented, which shall serve as the basis for determining whether probable cause exists and whether the warrant should be issued, must contain a particular description of the place to be searched and the person or thing to be seized. The above provisions are mandatory and must be strictly complied with. In this case, the only description of the affidavit presented to the judge was as follows: that there are being kept in said premises books, documents, receipts, lists, cheats, and other papers used by him in connection with his activities as moneylender, charging a usurious rate of interest in violation of the law. Taking into consideration the nature of the articles so described, it is clear that no other adequate and detailed description could have been given. Thus, the search warrant is not valid as to the third element. Now let us have a summary of the case. The search and seizure made are illegal because the warrant was based solely upon the affidavit of the petitioner who had personal knowledge of the facts of probable cause. That although it is not mandatory to present affidavits of witnesses to corroborate the applicant or a complainant in cases where the latter has personal knowledge of the facts, when the applicant's or complainant's knowledge of the facts is merely hearsay, it is the duty of the judge to require affidavits of other witnesses so that he may determine whether probable cause exists. And lastly, that a detailed description of the person and the place to be searched and the articles to be seized is necessary. Thus, the search warrant and the seizure and the orders of the respondent court are declared illegal and set aside. Thank you.